Hello and welcome to the Minimum Competence episode for Wednesday, May 22nd, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover Giuliani's bankruptcy court agreement to stop defaming Georgia election workers, Biden's milestone of 200 judicial confirmations, ABA facing discrimination complaints, and a hearing on sunsetting Section 230. Let's remember, every cloud has a silver lining, and if it's an iCloud, it might undelete your deleted photos. And read today's legal news. On this day in legal history, May 22nd, 1872, President Ulysses S. Grant signed the General Amnesty Act, marking a significant moment in the post-Civil War Reconstruction era. This legislation restored voting rights to most former Confederate rebels who had been disenfranchised under the 14th Amendment as a punishment for their participation in the rebellion. The act effectively reintegrated approximately 150,000 Southern men back into the political process, leaving only about 500 individuals still excluded from voting and holding office due to their high-ranking roles in the Confederacy. This move was seen generally as a step towards national reconciliation, aiming to heal the divisions caused by the Civil War. The General Amnesty Act reflected a shift in federal policy from punitive measures towards a more inclusive approach to rebuilding the nation. It acknowledged the need to bring Southern states fully back into the Union by restoring their citizens' civil rights. The process of granting amnesty to former Confederates culminated in a full universal amnesty on June 6th of 1898. By this time, all remaining restrictions were lifted, allowing every former Confederate the right to vote and hold office. This complete restoration of rights underscored the nation's commitment to moving past its divided history and fostering unity among its citizens. The General Amnesty Act of 1872 was a crucial step in this lengthy process of reconciliation and reintegration. Rudolph Giuliani reached an agreement in bankruptcy court preventing him from making further defamatory statements about Georgia election workers Ruby Freeman and Wandrea Arche Shea Moss. This accord, set to be approved by Judge Sean H. Lane, follows accusations from Freeman and Moss that Giuliani defamed them during an April live stream. They're also pursuing a $148 million defamation verdict awarded to them in December for Giuliani's false claims of voter fraud. Freeman and Moss had filed a lawsuit on May 10th alleging Giuliani continued his defamatory actions on his radio show. Giuliani's radio show was canceled earlier this month amid these allegations.
You all know I stand by the truth, and if I put my name on something, I truly believe in it. Today, I'm thrilled to introduce you to something I'm incredibly proud of.
President Joe Biden is poised to secure his 200th judicial appointment, with the U.S. Senate set to confirm U.S. Magistrate Judge Angela Martinez as a district court judge in Arizona. This achievement surpasses the pace set by his predecessor, Donald Trump, despite initial challenges due to a slim Democratic majority in the Senate. Biden's success in confirming judicial nominees, facilitated by deals with Republican senators, contrasts with Trump's more conservative appointments, which shifted the federal judiciary rightward, including the Supreme Court. Biden has focused on diversity, with two-thirds of his appointees being women and a significant proportion being racial minorities. Despite potential hurdles, the White House aims to continue pushing nominations to avoid more extreme outcomes in future judicial appointments. The Wisconsin Institute for Law and Liberty, or WIL, has filed complaints against the American Bar Association, or ABA, a federal judge, and 3 law schools alleging discrimination in student hiring programs. WIL claims these programs violate federal law by using racial quotas and preferences, which they argue have long been illegal. The complaint, filed with the Justice and Education Departments, targets programs that allegedly favor applicants based on race, age, and sexual orientation. South Texas College, the University of the Pacific, and Willamette University are also named in the complaint. Additionally, Will filed a complaint against federal magistrate Judge Leo Brisbois, accusing him of discriminatory practices in ABA's internship and clerkship programs. These actions follow the Supreme Court's 2023 decision to end affirmative action in college admissions. Other conservative groups have similarly challenged diversity programs at major law firms and universities, claiming discrimination against white men. The House Energy and Commerce Committee will be holding a legislative hearing today titled Legislative Proposal to Sunset Section 230 of the Communications Decency Act. This hearing aims to discuss draft legislation that would terminate Section 230 and push for new regulations. For those unaware, we have covered Section 230 in a Max Min episode available via a link in the show notes, but by way of brief background here, or reminder for long-term listeners, Section 230 of the Communications Decency Act was enacted in 1996 and is a crucial piece of U.S. legislation that provides immunity to online platforms from being held liable for content posted by their users. This law enables websites, including social media networks and forums, to host user-generated content without the risk of facing lawsuits for defamation, libel, or other legal issues arising from that content. Additionally, Section 230 allows platforms to moderate content in good faith, giving them the flexibility to remove or restrict access to content they consider objectionable without being treated as the publisher of that content. This framework has been key in fostering the growth and diversity of the internet as we know it today, for better or worse. While reforming Section 230 has been a contentious topic, sunsetting the law at this juncture is a misguided approach. Much of the internet's infrastructure relies on the protections offered by Section 230, which shields platforms from liability for user-generated content. This admittedly jerry-rigged but essential policy enables the free flow of information and supports innovation by allowing platforms to host diverse viewpoints without fear of constant litigation. Over the last 26 years, it has unquestionably done more to shield marginalized communities from the most virulent hate speech than it has been used as cover for bad actors, and while it also unquestionably needs tweaking, it needn't be discarded entirely. Removing the protections of Section 230 could immediately and irrevocably stifle innovation and severely impact small platforms that cannot afford extensive moderation. Although Section 230 is not perfect, completely eliminating it without a robust and well-considered replacement could lead to more harm than good. It is crucial that any legislative changes balance the need for accountability with the preservation of the open internet. And I get off my soapbox now, and thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. Reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email newsletter form. We'll see you back here tomorrow, and until then, remember, a journey of 1,000 miles begins by deciding between Waze and Apple Maps.
It's smooth, rich, chocolatey, and gentle on your stomach. It's so good, I even recommend drinking it black.